3 minutes.
All right, thank you. So there was a citizen that came up here and said that
the speaker has failed to identify himself in accordance with the rules of decorum.
That is hindering the public meeting. Will you please take care of him?
Ms. Werther, would you please ask for, like you do with everyone else?
Sure, I got it. I will introduce myself. I identify as we the people.
Okay,
Can I continue?
Go ahead.
Thank you.
Mayor, the speaker is required by the rules of decorum to state his name and city.
I identify as we the people, and my city is America.
I am a licensed attorney who studies freedom of information and other kinds of mass communication law issues. I'm not licensed to practice in Texas. I should be clear about that. I'm a Florida barred attorney. But I spent 6 years at UT studying Texas government and freedom of information and First Amendment issues around the state. Yeah, so the ability for the public in Texas to comment on government meetings is actually quite new. It didn't exist as a statutory right until 2019. So Texas Government Code 551.007 gives the public the right to testify, particularly at these local meetings. So it's clear that the agencies have to provide this right to the public to comment on agenda items. That's not an unlimited right. The government entities are free to make reasonable rules that could include something like how long a person can speak, or restricting someone to speaking just to agenda items only. But of course, the First Amendment protects a citizen's right to engage in political speech, and that includes criticism of government officials. And the Attorney General's office has been very clear that government entities are not allowed to prevent people from criticizing the government in these meetings unless the speech is unprotected by the First Amendment or there's a serious disruption. Now, what serious disruption means is up for interpretation. We don't have a lot of real clarity on that yet. But I can certainly tell you that using profanity, using expletives, unless they rise to the level of fighting words, and the words that have been used so far don't seem to, it's fully protected. You know, just because a city official takes offense to something that someone says doesn't mean that it's not protected by the First Amendment. The First Amendment has long protected anonymous speech in this country in various forms. There's absolutely nothing in the Texas Government Code that says that a person should be required to identify themselves before they speak on a matter. If a governmental body denies someone's right to speak because they won't identify themselves, I would certainly say that raises some First Amendment concerns. You know, we have this long history of protecting anonymous speech. Could there be some claims that we only want to hear from people who live within our jurisdiction? I could see those potentially being reasonable. We don't have a ton of guidance on that just yet. I would have real concerns as a member of the public having to state my address in a public forum in order to comment, right? This raises privacy concerns. It raises safety concerns. Certainly if somebody disagreed with you strongly and knew where you lived, that would raise some real problems. You know, in addition, I think that we have to realize that local government entities aren't just supposed to be responsive to people who live within their boundaries, right? I could live in one city and work in another city. You know, I currently pay taxes, local income tax, in a city that I don't actually live in. That local government entity should be responsive to me regardless of whether I reside there. So I can understand not wanting personal attacks and trying to create rules that might disincentivize personal attacks. But certainly if a particular person represents your district, or if they made a particular point that you want to address and want their specific response, right? These folks are elected and appointed to these boards in individual capacities. And so to have a right to engage with that person during public comment in an individual capacity seems like a pretty fundamental aspect of First Amendment protected political speech. So the Attorney General's office has clarified in some instances what would be considered reasonable. So, for example, time limitations are reasonable. That's very clear in the Attorney General's guidance. It's also very clear that it's not reasonable to prevent criticism. It's not reasonable to cut someone off based on the content, the viewpoint of their speech. Other things, whether or not they would be reasonable, those are when we talk about the open meetings and open records laws, those are things where oftentimes the Attorney General will give an opinion about what's reasonable. But certainly for citizens who think that the rules are unreasonable, typically litigation is really the only means of enforcement. So the parameters of the First Amendment have nothing to do with civility or being nice or saying things that aren't offensive. In fact, the First Amendment was specifically designed to protect that kind of speech, right? There are very few types of speech that aren't protected by the First Amendment. In fact, even hate speech is protected by the First Amendment. And the idea behind that is we don't want the government to be drawing lines in the sand about what speech is going to be acceptable and what speech is not going to be acceptable. If we allowed that to happen, I'm pretty sure no government official would allow people to criticize them publicly. I think the Attorney General's position about time limits is very reasonable. Typically, we see about a 3-minute kind of mark as being reasonable. I think it's certainly reasonable to expect that folks will stick to items that are on the agenda. It's also reasonable to expect that the governing bodies will allow people to speak about the topic before they take action, right? As opposed to saving all public testimony until the end after they've already voted on everything that's on the agenda. So those three sort of basic things, I think, are innocuous. But I think what we have seen more and more is government officials who don't want to be criticized in a public forum. We've seen that when they've tried to block comment on their social media pages. When you run for office, you open yourself up to being criticized for the job that you're doing representing the public. This is particularly true in instances where government officials get paid to do their work, where they get special privileges as a result of their work, and where they have the potential to make policy and impact people's everyday lives. The Supreme Court recently, the U.S. Supreme Court recently decided a case about this, and one thing that is really clear is if a public official uses social media to do a part of their job function, right? So they are sending out official policy guidance and those kinds of things. They certainly cannot go user by user and block people based on the criticisms. It's a little less clear, and I think more up in the air about whether they could just simply turn commenting off completely. That's a little different, right? That's engaging in that kind of one-way communication is a little different. Listen, ethically, I don't think it's best practice as a government official to limit your constituents' ability to engage with you and to comment with you, and that's the whole point of social media. But it's certainly clear that if a public official is blocking specific individuals based on the content of those comments, that's problematic under the First Amendment. One of the things that cities have to worry about, particularly when you see people being arrested and removed from meetings, there is a federal law that protects you when the government violates your civil rights. It's Section 1983. And so a government entity that wrongfully removes someone from a meeting, arrests them, right, for their public comment, could be subject to a 1983 lawsuit. And personally, as taxpayers, we should all care about that, because anytime a municipality is facing litigation, anytime a municipality is having to pay fines for violating the Open Meetings or Open Records Act, that's coming out of our pocketbooks, right? That's not individually being charged to the mayor or a council member. And so when municipalities don't behave in ways that support public comment, that respect First Amendment and other constitutional rights, the costs that are borne by the city are actually borne by the taxpayers. So it really is important for us as members of the public to want them to act legally and ethically, to allow these kinds of public comments, to allow citizens to engage with them in these public forums. I think the first thing is to educate yourself about your rights under the Open Meetings and Open Records Acts. And there are explainers on the Attorney General's website that break it down. You don't have to be a lawyer like me to understand what they mean. But there are a couple of other options as well. The first is I would encourage people to reach out to the Freedom of Information Foundation in Texas to let them know what's happening so that people can keep an eye on it and monitor it. And if it really is egregious, there's no reason that someone shouldn't reach out to the Attorney General's office and report what's happening. Because oftentimes we see that these are not one-off incidents, that this is a pattern and practice of trying to limit the public's ability to engage with their elected representatives. And that can be a problem legally. So if there's some ability to establish this is a routine occurrence, that could lead the Attorney General or others to take action.